Before we commence, we would like to make it clear that though we have now initiated this procedure of adjournment slips, but the adjournment is not for the asking. We will be putting questions because we find that almost 80% cases you have circulated adjournment slips, and this is a hearing day. So hearing day adjournment slips henceforth we might not entertain unless there are compelling reasons. So
My lord,
please be informed.
my lord, may I please mention item 5 of hearing, my lord.
Yes, please.
I may be allowed to withdraw the writ appeal 347 of 2017
Yes.
with liberty if your lordship permits.
And counsel for the writ appellant craves liberty to withdraw the writ appeal seeking leave that the appellant may be permitted to avail suitable remedy in future if so required.
347 2017.
Accordingly, the writ appeal is disposed of as withdrawn with the liberty prayed for.
Oblige, my lord.
May I please? With a concern of others, sir, I beg to mention item number 25, Lordship.
Yes.
We have put a respondent side, Lordship. This honorable court has directed us to present the status report, Lordship, regarding the work in progress, Lordship. Lordship, we need some time, Lordship. Status report last time directed us.
Status report regarding what?
The work, Lordship. How many they have? Our stand is that already 40% substantial work has been completed, Lordship. Therefore, there is no live issues in this data, Lordship. But they are claim that the work is abandoned, Lordship. But our
What does he want? How much time do you need?
4 weeks time.
Yes, please.
4 weeks time.
Do you have any objection to prayer for time?
Today there was a direction upon them because we had on the last occasion alleged that the entire tender work has been stopped. And this is in connection to a challenge of a tender.
Right.
But 4 weeks, my lord, if it commences to your lordship, my lord.
So who is the successful bidder? Who is carrying out the work?
Respondent number 2 is the successful bidder, my lord.
So you are for the respondent number 2.
I am for the oil India Limited. Respondent 1, Lordship.
So
who is
tender
for the
was not-
respondent 2?
We are supposed to produce the status report, Lordship.
Okay. So you do it quickly.
Yes, sir. After 4 weeks.
Council representing the Oil India Limited. Praise for and is granted opportunity of 4 weeks to place on record the latest status report. We notify on 27th March.
Oblige.
May I please, Your Lordship. Lordship, item number 14, 15 and 16, Your Lordship.
Yes,
These are, we are from the state of Mizoram, Your Lordship. We are the appellants. Lordship, I need some accommodation because Lordship, the AZ is appearing in the matter. He's been specially requested by the state to appear in these matters, Lordship. But he is out of station. He's gone to Mizoram bench for some fixed matter. So I need accommodation for 2 weeks, Lordship.
A request is made on behalf of the appellant, state of Mizoram, to adjourn the matter as learned Advocate General would be appearing to represent the appellant. As prayed, list. The other side had no objection. As prayed, list on 20th March, 21st March.
Oblige, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item numbers 21 and 22 of today's list, my lord.
Yes, please.
I have tendered a letter of my lord adjournment yesterday with the consent of the council for the respondents.
Why do you need an adjournment in a hearing case, sir?
My lord, here, my lord, in this matters, my lord, I am being led by the Advocate General Assam. Today he is out of station. Matter pertains to policy decision of the state with regard to rehabilitation, my lord, of the riot affected victims. My lord, may I pray, my lord, Lordship may be pleased to fix these matters, my lord, the 3rd week of March, my lord.
It is stated by Council Shri so and so that learned Advocate General would be representing the state in these appeals. And he is not available today. As prayed, re-notify on when do we want?
My lord, can it be on 16th of March? It is a hearing day, my lord, Thursday.
Fine enough, 16th March.
I am so obliged, my lord.
The other side has no objection.
May I please, Your Lordship? Your
Yes.
Lordship, item number 6 and 7, Your Lordship.
Yes.
Your Lordship, my senior Yanan Karmakar has expired, Your Lordship. Petitioner instructed me to take some time, Your Lordship.
Yes, passed away. Okay. This court is informed that learned counsel Shri Karmakar has passed away and thus, time is required to complete instructions for appearance on behalf of the petitioner. as paid list after 4 weeks.
Deeply obliged.
May I please, your lordship, I beg to mention item number 4, your lordship.
Yes, please.
The matter was listed on 21st, the day before yesterday, your lordship, and the lordships were pleased to fix the matter on the 2nd of March. But inadvertently, it has been listed today, your lordship.
Please check the order sheet. It's wrongly listed. Order, in the order it was. Okay. Okay, as paid list on 3rd March,
2nd of March.
2nd March.
Obliged, your lordship.
Wait, please, the Lord.
Can even be a Yes,
Wait, please, the Lordship. I beg to mention item number 2. To Lordship.
yes, please.
In the order column, Lordship. Additional affidavit has been filed by the petitioner. We want to take instruction on that, Lordship. Kindly fix the matter after 10 days, Lordship.
Learned counsel representing the Union of India,
No, Lordship, I am for the respond number 4 to 8. KAS,
response number 4 to 8. Praise for it is granted. 3 weeks time to complete instructions.
Malad, can it be on
Wadi.
2 weeks time, my
2
lord?
weeks time to complete instructions for the developments made in the additional affidavit filed on behalf of the petitioner. List after 2 weeks.
Obliged, Lordship.
May I please, your lordship. My lord, I beg to mention item number 20 of today's list, my lord.
Yes, please.
My lord, I have taken consent from the respondent side, my lord. I am for the applicant, my lord.
That's all right, sir. But why an adjournment in a hearing matter?
My lord, my senior, Mr. Vishidas is unwell, my lord. He is on leave, my lord. Can it be fixed on 16th of March, my lord?
Is it okay? As jointly paid list on 16th March. This for hearing on 16th March.
Obliged.
May I please, Lordship? Lordship, by taking consent from the other side, I beg to mention item number 27 of today's daily list. Lordship, my senior will remain outside for 2 days, Lordship. Therefore, Lordship, the matter may adjourn for the day.
Other side? No one?
Lordship, I have taken consent from the other side already.
Okay, very well. And counsel representing the respondent pays for time. List after 2 weeks.
May I please, your lordship, I have already prayed for adjournment and item number 8. For
Yes.
the
What for,
learned
madam?
counsel,
This is a writ petition of 2017. Why do you want an adjournment?
the arguing counsel, Ms. ML Gope is currently unwell.
Okay.
So personal inconvenience, she cannot be there in the court.
Very well. Request is made to adjourn the matter on the ground of ailment of petitioner's counsel. List on 16th March. Yes, please.
Please, your lordship.
Adjourn. Yes,
My lord, I beg, with the consent of the other side, I beg to mention item numbers 9 to 12 of the daily list, my lord.
yes, please.
My lord, the learned
This is not the
advocate-
daily list. This is the hearing list, madam. You need to correct yourself. Yes, these are hearing matters. Yes, please. Carry
Yes,
on.
my lord. In the hearing column, my lord,
Yes.
the learned advocate general is out of station, my lord. I pray for adjournment.
A request is made to adjourn the matters for the reason that learned advocate general who represents the state of Assam in these cases is not available today. Re-notify on 23rd March.
Deeply obliged.
Item number 28 of supplementary list for motion.
May it please, your lordship. There's nothing. Now, in this case, the petitioner availed a case credit facility of 50 lakhs from the respondent bank, lordship. And subsequently, the mortgage property against his loan credit facility, lordship, is going to be e-auction, lordship.
Why are you not supposed to go to the DRT, please?
Lordship, because my lord, lordship get some instant relief in this case because lordship, this is
The DRT is competent enough to grant this instant relief.
Lordship,
What to do with the law as laid down by Supreme Court in authorized officer versus State Bank of Travancore?
Lord.
Why are we supposed to entertain the writ petition, sir?
because my lord, it's a dwelling house lordship and there is perhaps no other residential property.
Is there any exception in the law as laid down by the Supreme Court for entertaining a writ in a DRT in a securitization matter? Please show us any law.
Yes, if my lord, the petitioner's house is going to be re-auctioned lordship, his lordship right to residence and.
No,
right to
the
life,
date you mentioned
Lordship,
in para 13 is 24th December 23. So a lot of time is there.
24/2 lordship, perhaps it's
Just check page 8.
wrongly.
You've got loads of time on your head.
Lordship,
He can reconstruct a new house.
but just wrongly,
Brother,
but it was written in the
writ jurisdiction can't be invoked. Supreme Court is very categoric in this regard.
lordship.
So
But my lord, his right to lordship residence will be curtailed lordship.
that is true that a man has to realize
And then he
before taking a loan and defaulting on that.
is ready and willing to pay lordship some amount in this regard lordship.
You should pay, approach the DRT, seek some kind of arrangement for making payment in installments. The competent forum is the DRT.
But the auction is on tomorrow, my lord, some protection is required on tomorrow lordship, 24/2.
So what to do? Why didn't you approach earlier? Why didn't you advise your client accordingly that you have to approach the DRT? Is the DRT not functioning here?
Functioning
So
lordship,
then you move immediately.
lordship,
What prevents you from doing that?
lordship.
The writ petitioner had availed rupees 50 lakhs as crushed his facility from the respondent bank. First up, since the repayment, since he had defaulted in the repayment, the account had become NPA. As such, the respondent bank had issued notice under section 13(4) of the SARFAESI Act, issuing a proclamation, and thereafter notice dated 17/2/2022 was issued for putting the mortgage property to auction sale. The present writ petition has been filed with a prayer to grant some time to the petitioner to make alternative arrangement. Full stop. After going through the statements made in the petition, we are of the view that the notices are appealable under section 26, is it?
17
17 of the SARFAESI Act. So in view of the law laid down in 20,
State Bank of Travancore versus authorized officer State Bank versus State Bank.
we are inclined to entertain this writ petition. However, the petitioner is granted leave to approve the learned PAT by filing appropriate statutory appeal. Matters to exclude.
Obliged.
Item number 1 of daily list for admission.
Why is it for division?
May I please the lordship, I beg to withdraw the matter.
I don't know the rest why it is before division bench. Because simply a direction is sought upon the respondents to register a document.
Yes.
Why it comes to division bench?
These are bench for matters, civil bench for matters.
Perhaps, my lord, that reassignment deed for a debt which is required to be registered, it is my lord, consequence of the SARFAESI Act,
Doesn't matter.
my lord.
This is not basically a proceeding arising out of SARFAESI Act.
Basically,
Anyhow, very good. He wants to withdraw then.
Petitioner's counsel safely withdraw this writ petition. Prayer allow. 8 petitions stand disposed of on record. Mr. So and so. We are putting it.
obliged.
Item number 29 of supplementary list for admission.
Or we have to match.
My lord, I appear for the appellant in this matter, your lordship. My lord, the matter is related to a quashing of a notification by dint of which half a mile of 14 rivers of Mizoram are declared reserved forest, your lordship. The notification was way back in 28/1/1965, your lordship. But by judgment and order dated 27 January 2021, the single judge quashed the notification. My lord, we were not a party to this petition, your lordship.
You have been
If my
granted
lord-
leave, file an appeal.
No, my lord, we have already been granted a leave. We went to Supreme Court and filed an SLP. My lord, Supreme Court granted us a leave to file an SLP with your lordship, my lord. Now, the matter is that, your lordship, that on 17th January, your lordship, we were granted a stay order
On the single bench judgment.
on the notification, your lordship. The status quo as regards to the condition of the forest for the notification dated 21/1/1965, which has been set aside, shall be maintained in the next returnable date. Now, my lord, the acting chief justice was not sitting on 14th, your lordship. The matter was listed on 14th as item number 2, my lord.
14th February.
14th February.
Why do you
My
need
lord,
to mention these things?
my lord.
It is listed in the court. Why acting chief justice or whatever? It is before division bench number so and so.
Yes, my
Yes.
lord. But at that point of time, acting chief justice was sitting and he was taking up the matter, your lordship. And he was not sitting on 14th, and therefore the matter was mentioned before the special bench, my lord, and thereafter again the matter was listed before my lord. In the meantime, my lord, the no interim order was there.
It was not continued.
It did not continue, your lordship. Now, your lordship, I pray before my lord, since there was already an interim order, my lord, kindly extend the interim order, your lordship.
Why don't we hear the matter finally? What is the difficulty?
Here only a lordship due permission. Today also I'm a stranger in this case. There's a lordship will remember on 16th I have filed an application for taking leave of this honorable court to file implement petition because I am the affected person. NSADCL, we are the constructing. Land was handed over to us, my lord. Then we paid 280 crores to the affected parties, my lord. Thereafter, these are honorable court person
Case of a
status quo
reserve
order.
forest, sir, just hold on, please.
My lord.
We'll hear your implement application. There is no
Yes,
difficulty.
yes. No, today
But
I,
just-
lordship,
hold on.
my
hold on.
prayer before lordship, if
My lord,
lordship, my
if-
submission only, because he's also rightly saying because it is to be continued because due to technical fault.
No,
Now
stay
that
will be
is also
continued.
there.
There is
That
no
is I am before your lordship. My submission only, due permission only one submission is there. My implementation as your lordship is kind enough to grant to file implementation. Today I am filing because yesterday I could not from Calcutta. I could not supply to the anyhow, my lord. Today I am filing implementation.
You must be knowing her, having her email address.
No, anyhow, my lord. That
You
point
must
I will
have
not go.
email address.
Today I am filing, my lord. Today I am filing.
Don't take these
No,
excuses.
no. I'm not taking, my
Things
lord.
are
Today.
likely to change.
No, that's it.
This
Yes.
Physical supply of
I'm
copies.
beg apology, my lord. For that, I'm withdrawing. Now I have filed today. Rather means after half an hour, I'll file this. I have the copy served. Implement petition and this. I think if we go by super technical, I don't want to go by super technical also. In between gap is there, vacuum is there for status code. I
You know,
suppose
sir,
to file.
if there is a status quo order passed by this court,
My lord.
bench is not formed, the order could not be passed unless it is rescinded or revoked. It is deemed to be continued.
My lord.
That is the intention of
That
the
is
stay order.
Then I am submitting only, my lord. There is come. My implement petition as it is very
You'll be
beginning. I
filing
tell
it
I'm a
today.
stranger.
To make it short, you will be filing it today.
Today I'm filing.
Okay.
And as 2 weeks time is granted, accordingly, the lordship was granting 2 weeks time.
So,
That comes.
so for that matter, if you go on a hyper-technical issue,
No, I'll not go
time
now.
for filing
No,
implement
no,
is
no,
gone.
No, I'll not go down.
Close your
No,
opportunity.
I'll not go that. That also I'm withdrawing.
Don't stand on those ceremonies, please.
No, my lord. Now I'm withdrawing on that also.
You know, from our experience in Rajasthan, this is for benefit of Mr. Chaudhary. There is no category. There was no category in my court. Every case which was listed could be taken up for hearing at any stage.
Yes.
So there's these technicalities, they don't matter.
No. Because,
So you move your implement.
no, I'll not go.
We'll continue the stay.
That is also been withdrawn by me, my lord. Deep apology. Now my implementation today I'm filing. That is my
And
submission.
council, Shri so-and-so proposes to file the implement application in terms of permission granted on 16/2/2023 during the course of the day.
My lord.
Ad interim order dated so and so shall continue until disposal of the writ petition, till disposal of the writ appeal.
My lord, obliged.
We'll all have to examine the
Yes, sir.
consequences of T and Gondavaram.
Yes.
Yes, this term.
Obliged, my lord.
List, when we want, we'll be filing the application today.
Today I'm
We
filing.
need time to respond.
That earlier 2 weeks maybe. As earlier.
Response, if so required, to the application be filed by 2 weeks.
Right.
Within next 2 weeks.
So
You
Lordship, the matter may come maybe after 3 weeks, Lordship. We'll look at,
No.
I'm appealing for the state.
List on 27th March is okay.
Fine.
Within next 2 weeks, within 4 weeks.
Obliged, my lord.
Deeply obliged, Your Lord.
Item number 3 of daily list for hearing.
Why don't we take this 31? Let it be taken up. This has been posted from yesterday to today. Let us take this matter.
May I please, Your Lordship? Lordship, I beg to inform this honorable court that this matter may not take up, like to take up by this honorable court, Lordship, because our matter is also tagged, that is 6710/2021. Lordship, my senior is engaged in this. Yes.
The item number.
Who is
You're
your
mentioning
senior?
for number 3.
Yes, Lordship. Item 3.
Who is your senior?
D goes, Lordship.
Huh?
There was Mita goes.
List before a bench of which Honorable Justice Sham is not a member.
It will be listed on 23rd of March, not
Re-notify on 23rd
3rd of March.
March. Very well. Right.
Item number 31 of supplementary list for hearing.
Where's the council? Both sides missing in action. You take up the remaining cases in the hearing list. Pass it over.
Lordship, the time being, Lordship.
Timing. Call out the remaining cases, please.
Lordship, pass it off for time being. I shall inform.
Yes, we are passing it on.
Item number 13.
PIL देखना भाई सब क्या चीज है
May it please the Lordship. This is a PIL that has been directed against the encroachment of a particular Qabristan. It's a burial ground in the city of Guwahati called the Guwahati Adgaon Qabristan. Now, if your Lordship will come to page 35, Lordship will see that
Who is appearing for the government in this case? Who is for the government?
Government, I don't know. But I am appealing for the persons who are the tenants over there. Mala, there is a committee, Adgaon Qabristan committee.
No, that's all right, Mr. Roy.
I am the tenant.
We'll come to that. Mr. Majumdar. You see, there are a lot of writ petitions which come to the court where the allegation is encroachment of public land allotted to this body, that body.
So we'll share a judgment from Rajasthan that goes by the title Jagdish Prasad Meena. So we worked out a mechanism that in every district, there will be a cell called Public Land Protection Cell. And in case any complaint was filed, the district magistrate being the chairperson of that cell, the inquiry would be held, because in writ petitions, getting the evidence, analyzing the facts, physical evidence, that would not be possible. So that has worked out fine. And in case such writ petitions come in, the immediate direction is go to the PLPC, file the application, it will be decided accordingly. So we'll just get the judgment downloaded. Please have a look at it.
In this case, the government has filed their affidavit wherein they have admitted to the fact that enforcement has taken place in that area.
It is very important from the point of view, my lord, because although the enforcement is illegal, they come up with some construction, then they raise a objection.
So
that no objection was raised, we have made our
that would not matter, because if the land is otherwise a public land,
Yes.
and if it has been encroached upon, demolitions have to be done.
Yes,
There we are on a different scale.
whatever may be the duration of possession, that will not give them any right.
Yes, precisely.
Right.
So we'll just share the judgment
Minor.
with you. Please have a look at it.
My lord.
Where is the state council in this case?
My lord,
You- What are your instructions, please?
oh, my lord, sorry, I'm not in this case. The Rajasthan High Court that your lordship is there, I live here.
No, we are, that judgment we are sharing
My lord,
to be followed in appropriate matters.
my lord,
We'll just share the judgment with you.
my lord.
Just have a look at it. Regarding in this matter, who is representing the government?
My answer is there.
She seems to be holding only the fastest, nothing else.
Okay, Lordship, advocate general, he is appearing.
Earlier,
That's
the
why-
AG had issued appear in this matter.
क्या करेंगे सर? 2021 department.
And the government had admitted that encroachments have taken place therein. Inspection was done, government had admitted that encroachments are
Not
there.
that way. There is a committee framed by the deputy commissioner, who is a Adga Kabarstan committee. There are two parts. One is the graveyard, one is the Idgah.
Excuse me, Mr. Council.
Yes.
Is this property not covered under the Waqf board? Doesn't it come in domain of the Waqf board?
No, to my instruction, it is not. It is a government land. The Jamabandi would show there is a government land designated for burials only. That is at page 35.
So then, just we pass it over. You have a look at that judgment.
Yes, sure.
I think that should cover this controversy. Nikaliye.
My lord, your
We're
lordship,
just passing it over for the time being.
my lord, your lordship may fix it on first.
All right. We re-notify on 1st March.
First.
We'll share the judgment with
My
all
lord,
of you.
we'll look into
Please
it.
have a look at
And then we can
it.
come back.
It's a fairly good mechanism
My
to
lord,
deal with these issues.
Oblige, Lord.
it will be fixed on first, my lord.
1st March.
Item number 17.
In person.
Senior is sitting stuck in another court, so matter may be possible for time being.
You want to pass over?
Yes.
For the timing?
That's all.
I'll pass it.
Item number 18.
Is this only a second?
18.
Please, Your Lordship. No, this is against the wide scale encroachment of Hunai Rupa and Nameri landscape discovered. About 8 reserve forests and 1 wildlife sanctuary, my lord. And during the course of hearing, the forest department has admitted regarding the encroachment. And on the last occasion, they have sought time to bring on record the steps which they've taken.
Today the government seems to be in a slumber.
Forest department is appearing.
Mr. D. Gogoi appears for the forest department. Madam. At the bar, he informed us.
Item number 19.
Lord, in this PIL, my lord, we have projected the whole picture of the state as far as forest is concerned, my lord. How the forest cover has decreased. My lord, fortunately, yesterday after 4 months, we had a spell of rain and we got some respite. My lord, I have spoken with the additional advocate general of the state, my lord. He was also saying we are not construing it to be an adversarial litigation.
It should be a concern for all.
Yes, my lord.
True.
My lord, here what we are saying is basically, my lord, every forest district division should have a working plan. My lord, when we applied under the RTI, it was not forthcoming. It is not there. Then, my lord, there is rampant felling of trees are going on. Rampant earth cutting is going on. My lord, not to speak of any other place. Guwahati city itself, lordships will find at least 100 dumpers are carrying earth, my lord. With the my lord, eyes open, nobody is doing anything, my lord. I think time has come, my lord, we do something. My lord, can I suggest one thing, my lord, subject to your lordship's consideration? The present PCCF, he is a, my lord, very capable person. I personally know him. Would your lordships ask him to assist the court how this problem can be solved, my lord?
Let's call
Not by way of an, I mean,
he can address us through VC.
yes.
Yes.
He's the present man, is a very capable person, my lord.
The learned counsel for the forest department is.
Lordship can have a fix a date where he will appear and let him address, my lord, how these issues can be addressed.
So the suggestion of Ms. Chaudhary is reasonable or rather justified. Let your officer be there through VC. Okay, when do we fix it?
Any day subject to my lordship.
On the request. Let him
Let him come personally.
He is in station in Guwahati.
Guwahati.
So he can very well come down. On the suggestion of Shri Chaudhary, Senior Counsel Shri Chaudhary, we hereby request the next state council to ensure presence of PCCF.
Principal Chief Conservator of Forest.
Name, what is the name of the man?
MK Yadav.
MK Yadav.
Shri MK Yadav to remain present in the court for assisting us in this PIL.
Lordship, may kindly fix a date, my lord.
On one day of the week. Mr. Chaudhary.
My lord.
Many environment matters are coming up.
Yes.
So we were thinking, deliberating, we should have a dedicated bench for that.
Sure, surely, my lord.
Think of that. Yes. We have placed some matters before this bench on what date? 2nd March probably. 3:45. Fix it on the same day at 3:45 before the same bench.
Deeply.
In the meantime, please have a look at that judgment.
My lord,
That would solve many problems.
28, 345.
28, we don't have court.
28 is a reference date.
So we'll postpone it then.
All these 28 matters have to be shifted to
Shifted first, second.
2nd of March.
2nd March.
Deeply.
वो फिर 3:30 कर दीजिए. 2nd March 3:30 PM before this bench. So simply list next week कर दीजिए आप. Before same bench.
Second of
Thursday, hearing day में second of
Deep
List next week. Before the bench of which both of us are.
Item number 23.
Lordship, I am petitioner in person, Prakash Chandra Stoikia. My amicus curiae advocate Ms. Devasi Stoikia will be on.
She is already there. She
Yes,
is
she
joined.
is out of station on her sick father at Hyderabad.
Lordship, may I, Lordship?
For you,
Yes.
for the first time, some document, if you would allow, for related with the lead appeal.
It's a challenge against a single judge's order.
If you want to file certain additional documents, they have to be
They have to related with the lead appeal, sir.
It is okay, Mr.
Lordship, may I,
Petitioner.
Lordship?
Yes, madam.
Lordship, the documents which the petitioner in person wants to place, they're already in the writ petition, Lordship. So he just wants to give an additional copy, Lordship.
Okay, okay, very well.
Lordship, may I start, Lordship?
Sure.
Lordship, in this appeal, the appellant prays for the granting of back wages, Lordship. And this appeal is against the order of the learned single judge of this court, Lordship, dated 17/12/2020, wherein the appellant sought for a direction from this honorable court seeking back wages, Lordship. But his prayer was rejected, Lordship, and hence this appeal is filed, Lordship, before Lordships. Lordship, if I may summarize the facts, Lordship, briefly. Lordship, the appellant was a teacher of lower primary school at Maijan Tea Estate, which is presently known as the Greenwood Tea Estate, Lordship. That is the respondent number 2 in this appeal, Lordship. And he was transferred to another tea estate, and when he did not comply with the transfer order, he was dismissed from service on 11th of July 2002. He was appointed as a teacher of lower primary school, Lordship, on 4th of July 1980. 4th July 1980 is the date of appointment of the appellant as a teacher of lower primary school under respondent number 2, and he was dismissed from service on 11th of July 2002. Lordship, thereafter, after his dismissal, a series of litigation took place, and the matter finally reached the Honorable Supreme Court, Lordship. The Supreme Court, our prayer was that the dismissal order was wrong and hence we should be reinstated into service. But Lordship, the Supreme Court, by order dated 14/7/2017, directed that the respondent tea estate to pay a sum of rupees 5 lakhs as full and final payment to the appellant. And the Supreme Court, Honorable Supreme Court, did not say in so many words that that he should be reinstated into service, or that his dismissal was irregular, or his dismissal was null.
Settlement would cover everything, madam.
Lordship,
the intention of the order is very clear, that it covers everything.
Yes, your Lordship.
Lordship, that is at page number 172, Lordship. If I may read the order once.
Yes, please.
Lorships have found that in page number 172.
Honorable Supreme Court's order you are referring to?
Lordship.
That is at page 85.
Page 172 of the writ appeal.
Same order. Except 14.
Yes.
It is at page number 172 of the writ appeal,
All right,
Lordship.
it's okay. It's okay. We are having the order. Please carry on.
May I read, Lordship, the order?
Yes.
Leave granted. Heard appellant who appeared in person and also heard learned counsel for the respondents. Having regard to the facts and circumstances of the case, we are of the view that the appellant ought to be paid by respondent number 1 a sum of rupees 5 lakhs in full and final settlement of his claim, ordered accordingly. The said amount be paid within a period of 3 months from today. These appeals are disposed of accordingly. Pending applications, if any, shall stand disposed of. So, Lordship, ordinarily the matter should have ended there, because he was given full and final payment as per the order of the Honorable Supreme Court. But Lordship, what the respondent authorities did was that after he was paid the 5 lakhs as full and final payment, they also reinstated him into service. Even though the order of the Supreme Court did not say anything about reinstatement, the appellant was in fact reinstated into service by the respondent authorities. So, Lordship, now our primary contention of the petitioner appellant is that his rejoining of service in 2017 is not a fresh appointment as claimed by the respondent authorities, but it is a continuation of
the reinstatement order, please? Can we have a look at the reinstatement order?
Yes, Lordship. Lordship, there is no particular order of reinstatement, but he was given just to join the institution by an order dated 9/10/2017, which is in page number 114 of the writ appeal, Lordship.
This is.
May I read the Lord? Page number 114 of the paper book, Lordship, writ appeal. If I may read, Lordship.
This refers to an order dated communication dated 4/10/17. Can we have the benefit of that communication, please?
Lordship, it is not 4/10, if I may, if I'm right. Lordship, it is 9th of October.
We have brought it on record in that affidavit.
This communication which you are referring to reads that this is in a continuance of a letter dated 4/10/17. Are you having that letter with you?
4/10/17, Lordship, I am having the 9th October 9/10/2017.
Please read the contents of 9/10/17.
Yes, Lordship, it is in page number 114.
Yes, we have that. We have that.
This refers to the letter received from acting manager Maijan T Estate dated 4th. Yes, it refers to 4/10/2017.
What is the letter dated 4/10/17?
We have filed an affidavit in March 2022.
Lordship, 4/10/2017 is in page number 113. 113, Lordship.
It is there, 113.
Yes, Lordship. It is on the prior page, 113.
Can you explain this, Mr. Counsel? Why he was taken back in service?
He was never reinstated. On a humanitarian ground, he was only allowed to join as a press appointment. And that your lordship will find.
Under what procedure of law?
On a humanitarian ground, he was allowed.
Terminated employee.
Yes.
Can he be taken back in service, sir?
Pretty
Your
appointment.
authorities, as a matter of fact, we feel that disciplinary action is required against your officers.
The situation.
What kind of indulgence is this? We call upon your officer, whosoever he is. Under what jurisdiction he has done this?
My instruction was that on that particular day, as a humanitarian ground, a reappointment was given to him.
Gentlemen, what power does any recruiting authority have to offer appointment to a person who is terminated? And contrary to the Supreme Court judgment.
Yes.
We ask your officer to furnish an affidavit how he has done it. And if we find any fault, we'll direct his termination. This is too much. Unacceptable, totally.
That is true.
Then why didn't you advise your client accordingly? It is supposing a case of wrongful reinstatement,
yes,
then appropriate action should have been taken there and then.
Yes. So my instructions, when I was handled the brief, my instruction was this a fresh appointment or a continuation of the earlier appointment?
Fresh appointment in pursuance of what kind of procedure?
It's a private. It's a private estate, so probably I think they have taken the liberty of.
It's a private estate.
It's a private estate.
Very well.
So probably they have taken the liberty of giving him a humanitarian reappointment.
So where is that decision?
Yes. If your lordship will see at page 137, a reference is there. In fact, I'll take your lordship directly to that order itself.
Yes.
The order lordship will find there's an additional affidavit been filed because the query was raised on the earlier occasion as to where is that order because the petitioner has not brought it on record. The lordship will find the additional affidavit was filed by us on March 2022. by the respondent number 2, Maidan Tea Estate, and therein,
And the company has gone into insolvency.
in fact, Lordship, the matter has been totally digressed in a different context altogether. The writ petition was dismissed on the ground that the particular company had gone into insolvency, and therein, before the RP, he had submitted his claims. His claims were rejected. And thereafter, he didn't prefer appeal under section 61 of the IBC Act. And on that ground, it was dismissed. The company went into insolvency. It's a new company now. In fact, the entire matter has gone on a different tangent altogether. Before the single bench, it's a new company now. It's a new company has gone into insolvency. He has applied claim.
Next on record.
Yes, it's everything is on
IBC,
record.
the resolution.
Yes.
Is the resolution.
Yes, Lord, that's correct.
Where is that?
Page 175 is his claim before the RP. The Honorable Single Judge has held that these were all suppressed, and therefore this petition was dismissed.
Oh.
He has suppressed everything. Page 175. Lordship will see this is the list of claim of operational creditors, and therein at serial number 161, Lordship
Yes,
will
we find his name.
serial number 161, next page.
Some 61 lakhs.
61 lakhs.
15,247.
For that period which he have not worked, and where there was no orders of reinstatement by the Supreme Court.
And the resolution plan has been approved by the NCLT?
Yes, has been approved by the NCLT, and that will also will find at page 177.
Where is the approval?
Yes. 177 is the resolution plan, and the judgment, Lordship will find the NCLT judgment at page 194. 194 and page 200, paragraph number 13 is the approval of the resolution plan, Your Lordship. All these issues were suppressed before the single bench, and the Honorable Single Judge have rightly held, therefore, that you had the right under section 61 of the IBC to have appealed. If your claim was rejected, you didn't do so.
Precisely.
And you came to the High Court in a writ petition, and therefore it was dismissed, and you came without clean hands. So that is the basic crux of the matter.
Madam, would
We
you
are
be
digressing in a
persuaded
different
to
direction altogether.
advise your
Lordship,
client?
may I, Lordship?
Just hold on, please.
Lordship, the contention of my senior friend is not correct, Lordship, that we have suppressed like matters before the single judge, because we have
Let
made.
us see your pleading, please. Let us see your pleading, whether this fact has been disclosed. Because if this fact has been concealed, we would be persuaded to dismiss your writ petition with heavy cost.
Lordship, this
that you
fact.
must take into account. Read your pleadings, please.
Page 244, paragraph 9 is the finding of the Honorable Single Judge. Page 244, paragraph 9. 244, paragraph 9.
Read para 9 of the.
Yes,
order.
Lordship. Sadly, there is not a whisper in the writ petition of the claim made by the petitioner before the resolution professional, as well as the fact of non-admission of his claim. This, in the opinion of the court, amounts to not approaching the court with clean hands by disclosing all relevant and material facts. Lordship, we have refuted that in the writ appeal because we have already
Madam,
made the.
please read your pleadings in the writ petition. Point out where you have mentioned this. Refuting in the writ appeal is of no purpose. Point it out from your pleadings.
लॉर्डशिप लेबर कोर्ट में जब हम केस किया था तो इसमें वो की वो इशू तो एराइज नहीं किया है, तो फाइनल स्टेज में तो रिजोल्यूशन प्रोफेशनल का
रिट पिटीशन कितनी तारीख को पेश किया आपने?
2018 में रिट पिटीशन फाइल किया,
रिजोल्यूशन
तो हम लेबर कोर्ट में फाइल किया।
मिस्टर पिटिशनर, आपका रिजोल्यूशन प्रोसेस 2018 के पहले खत्म हो गया था। वो फैक्ट आपने लिखा, हम आपको साफ बता रहे हैं, बिल्कुल स्पष्ट शब्दों में, ये फैक्ट रिट में नहीं डिस्क्लोज्ड है, वी विल इम्पोज हेवी कॉस्ट ऑन यू। आपको जो अभी तक मिला है वो सारा वसूल हो जा रहा है, ये आप सोच लीजिए एंड कम बैक टू अस। वी आर वेरी स्ट्रिक्ट इन दैट। इफ अ मैन litigant comes to the court by concealing facts, we will come down heavily. सोच के
लेबर कोर्ट में जो हम फाइल किया है मिस केस, तो इशू राइज किए।
That's the order he got.
Madam, you read from the pleadings of the writ petition and talk to your client. we are taking the matter back after a few minutes. If we
Lordship,
find that there is a non-disclosure of this fact, then we will impose costs. Whatever has been paid to him might be recovered. And he might also lose the job which has been given to him as benevolence.
Lordship, he has already
just ask him.
retired now.
Okay, then, well, then he'll lose the financial gains. Ask him. We are passing it over for the moment.
Deeply obliged, Lordship.
Preposterous. What kind of lengths a litigant can go? And then filing an appeal even in this matter. Strange. Pass over for the timing.
Sir, Ms. Saikia,
Lordship,
you see, yes, hope you understood the implications of the queries made by my lord.
Lordship,
You see, the learned single judges categorically observed that there has been suppression of relevant material facts, which is pertaining to the IBC, the insolvency proceeding. Apart from that, the Honorable Supreme Court has already directed he should be paid 5 lakhs as full and final settlement. Thereafter, asking for 61 lakhs something for that period where he didn't work, that too in a writ petition which was dismissed. You need to examine what you are asking for. Over and above the query, His Lordship.
It was just a collusive conspiracy amongst your officials and this man, plain and simple. So let him think over it. Come back in a few minutes.
Lordship, I am the amicus curiae in this case.
We
So
know your
whatever is-
limitations, madam. Just let your client, let the litigant petitioner know what the implications can be. You just talk to your client. We know your position. You are
लॉर्डशिप जब सुप्रीम कोर्ट में फुल एंड फाइनल सेटलमेंट दिया है हम सिविल कोर्ट में
discharge you from your responsibility. We'll hear the petitioner and decide accordingly.
Yes, lordship.
Lordship.
Will not put you in a difficult position.
Lordship.
Deeply obliged, Lordship, I'll talk to the client. Lordship, I'm talking to the petitioner now. Deeply obliged, Lordship.
आपको बात करनी है अपने एमाइकस से या आपको खुद से बहस करनी है, बता दीजिए.
लॉर्डशिप, जब सुप्रीम कोर्ट ऑर्डर दिया है फुल एंड फाइनल सेटलमेंट एंड लीव हमारा ग्रांटेड किया है, तब मैनेजर का हम पास गया था. मैनेजर बोला है जो आप सिविल कोर्ट मत करो, हम 5 लाख भी दे देगा, वो आपको सर्विस रीइंस्टेट कर देगा. तो इसीलिए हम सिविल कोर्ट में नहीं आया है. सिविल कोर्ट में नहीं आया है तो हमको रीइंस्टेट कर दिया है. रीइंस्टेट कर दिया है तो बाद में केवल को
हम वापस बता रहे हैं कि आपको जो मिला है वो भी वापस वसूल हो जाएगा आपके एसेट से. आप सोच लीजिए, झूठ बोलकर कोई लिटिगेंट कोर्ट में आता है,
झूठ तो नहीं
हम माफ नहीं करते. ये आपने आईबीसी वाला प्रोसीडिंग या रिट में बताया था.
सर आयो रिजोल्यूशन प्रोफेसर तब तो कंपनी देवलिया हो गया. कंपनी तो चेंज नहीं है, असम कंपनी लिमिटेड है. जब नहीं मिला है तब हम लेबर कोर्ट आया है, लेबर कोर्ट में फाइल किया है, लेबर कोर्ट में ऑर्डर तो है पेज एंड तो
चलिए ठीक है, हम आपकी अपील 5 लाख की कॉस्ट के साथ डिसमिस कर रहे हैं. ठीक है
लॉर्डशिप सर, हमारा केवल हमारा
वकील साहब से बात कर लीजिए. जस्ट होल्ड ऑन
लॉर्डशिप,
अपने लॉयर से बात कर लीजिए.
अच्छा
10 मिनट में आके बता दीजिए.
ठीक है.
We'll talk to you after 10 minutes. Come back after 10 minutes.
Deeply obliged.
Matter number 24.
She is unnecessarily in a difficulty actually. As a matter of fact, the learned amicus curiae should not have been granted a brief with such a cantankerous litigant.
May I please, Your Lordship?
Yes, please.
In this case, Lordship, I have challenged the Honorable Single Judge order, page 93, Lordship, of my date. The relevant portion is, Lordship, page 94.
94.
94, the Honorable Single Judge has directed in view of the paragraph, Lordship, last paragraph, in view of the matter, this repetition is disposed of by directing the respondent.
94 is not the order.
Order of the Honorable Single Judge.
91, 92, my lord.
There's a table of dates. These are 99, page 100. There seems to be some mismatch in the page.
91, 92, Lordship.
This is 25th January 19.
25th January.
If we are having it at page 100.
Oh, Lordship, I'm
No
sorry.
issue, no
I'm
issue.
sorry.
Please carry on.
Please not. In last paragraph, Lordship, in view of the matter, this petition is disposed of by directing the respondent authorities to reconstruct the concerned certificate. That is pass certificate, Lordship, pertaining to the secondary course held in the month of April-May 2008. More particularly relating to the petitioners, and take steps to issue duplicate certificate with proper endorsement. The petitioner would also render necessary cooperation in the process of reconstruction. The reconstructed duplicate copy as directed to be issued shall be done within a period of a month from today. This petition, Lordship, in this case, what happened for us? In this case, we have filed affidavit also, the petition, mentioning all the facts that we have never issued any pass, this is provisional pass certificate. The regional director, NIOS, National Institute of Open Schooling, he has never issued any provisional.
It's a case of no issuance ever.
No issuance ever. Lordship, the regional director has no power to issue the certificate. Only the chairman issued from Delhi, Lordship. Only the chairman and the Lordship, the coordinator, the Lordship, he can only issue the pass certificate. Here, Lordship, what happened? In this case, the Lordship can kindly go to page 58, Lordship.
Contradictory. Then the original certificates from the left issue. And what's the question of issues of reconstruct? ये देखिएगा. I think they took up the records. No. See the para strictly look at from this does not deny the fact that the original certificates were in fact not issued to the petitioners. So this is a reverse kind of construction. Does not deny but not issued. That means that they were issued. Madam, what do you say?
What?
The second last paragraph of the impugned order.
Second last.
Shri P. Bhomik.
Yes, that is P. Bhomik. He has made the Lordship
statement.
Yes, he has said that due to
Not
mechanical
denying
fault.
issuance.
Due to mechanical fault.
No. Statement was made that there is no denial
that
regarding the certificates having been issued.
Certificate were in fact not issued to the petitioner.
Does not deny.
No denial.
So that means the certificates were issued
Not
in original.
Original, Lordship, because they have not appeared in the examination. For us, Lordship, because the certificate was a provisional certificate was issued relying on the only corrected results issued by the NIOS. That is page 56, Lordship. Because that provisional certificate was issued by the regional director, relying on the corrected results. Moreover, in the corrected results, Lordship, no date, no signature, no seal. On the earlier signature, occasion, Lordship.
Okay, there is another order. This is dated 27/11/2009. Mola early council made a wrong submission.
Okay, but that was dismissed.
That was dismissed.
Exam, that's what.
Ms. Chaudhary,
Yes, ma'am.
it appears that they are denying that your clients had ever even participated, appeared in the exam.
No, my lord.
So listen. Please listen to me quick. Then only you'll be able to answer. You might have enrolled for that April-May program of 2008. Your clients might have enrolled. But where is the document or other evidence to show that they had actually taken part
Yes, ma'am.
and completed the course?
Yes, my
Where
lord.
is it? Where is it? There is no finding in the order dated 25.
And then what is the reason
Your-
for the delay of almost
your
11
lordship-
years
Your
in approaching
lordship
the
may
court?
my lord.
Madam, what is the reason for delay of 11 years in approaching the court?
Yes. My lord, the petitioner approached, filed the writ petition, my lord.
In 2019 for a certificate of 2008.
My lord, the petitioner appeared in the secondary examination and they passed the examination. They appeared with late fees, my lord. So their results were declared, my lord, it was not declared in time, my lord. So there were several communications made by the authorities themselves. So thereafter, the results were declared, my lord. So in the meantime, my lord, your lordship may kindly see at Annexure D, my lord, at page 20 of my affidavit, my lord. Affidavit in opposition, my lord.
In writ, in the writ petition
In
or in the appeal?
In the affidavit in opposition, I have filed.
In the appeal, madam.
Here I am respondents, my lord, I have filed affidavit.
Is it in the appeal?
You have filed the affidavit in opposition in
Yes,
the appeal.
yes, my lord. That is, I have filed on
165. Is it page number 165?
page number, my lord. Page
4th
number-
August 2021.
28.
Page number.
This one, 4th August.
This is also affidavit by respondent. Additional.
Affidavit in opposition, August 2021, I have filed, my lord. There were no running page, my lord.
There is a pagination. It's probably at
Annexure C, my lord, page 18, my lord.
109.
109.
Running page.
Page number above differs. In fact, I have annexed the certificates, my lord, with my affidavit, annexure E1 and E2, my lord. Page 21 and 22 of my affidavit, my lord.
These certificates were before the learned single judge.
Yes, my lord. 21 and 22.
Those have not been considered. In the
Yes,
order.
my lord. My lord, after appearing, after passing the secondary examination, they took admission in the senior secondary. And there they got the
Yes,
admission
already-
and they passed the
Why-
senior secondary also from the same
Listen,
institute.
listen,
Yes,
why don't you understand the query? These certificates which you have brought in your additional affidavit filed in the writ appeal.
yes, ma'am.
These materials,
In the writ petition.
was those documents considered by
Yes,
the
my
learned
lord.
single
Yes,
judge?
my lord.
Where it shows in the order dated 25/1. Where it has been dealt with.
My lord, recently I filed an affidavit. There also I have annexed one, my lord, document from the issued by the respondents. There they admitted, my lord, your lordship may kindly see at page 150, my lord, running page of 150, my lord. There, my lord, there the respondent said your admission, that is regarding admission in the senior secondary, my lord.
pagination. Pagination is totally mess, madam. We just got
150 running page, my lord.
150.
The fact that they had appeared, my lord, becomes clear from this document itself, my lord.
फाइल मैडम को देना 150 दिखाइए. Show it to madam which document she is trying to show. Pagination tally करवाइए. It's just not possible to.
There's some problem with the pagination. It's not.
131.
It's not telling with the court's record.
131.
They record reports. Or they can flag it at least. You madam, you rectify the pagination. We'll
Yes,
take
my
it up
lord,
on
yes.
next hearing day.
We'll correct it, my lord.
Council for the parties shall rectify the errors in pagination in their own records. List for hearing on 14th March.
14 March.
कि एग्जाम में फेल नहीं होगा और आगे ग्रेजुएशन कर लिया
My lord, matter may pass over timing, my lord. I am appearing, my lord, on behalf of respondent number 1, my lord. My lord, the senior engaged counsel, my lord, Mr. S. Bothouse is another coach, my lord. Time being, my lord.
He seems to be a popular person as well. Okay, pass me.
Item number 30 of supplementary list.
30 is placed on 27th, 31. 30 is placed on 27th, 27th March. This is 31. Up Shahrukh Ahmed, you are having Shahrukh Ahmed. That is 31. नहीं होता अच्छा वो दे दी 30 दे दीजिए I'm sorry I may have written wrongly 30 दे दीजिए 30 से मैंने कहीं गलती से लिख दिया उसके बाद we are taking up 31st 30 31 we'll take it up, just wait. We'll take up 31 after this. You are in item number 30.
My lord.
Yes, okay. Please.
My lord, this case is only for the promotion from grade 2 to grade 1 within the stipulated period of time. Issue was whether within the period I have collected the premium. That was the only issue. That issue, my lord, lordship, the impugn order, impugn judgment at page 95, lordship.
$95. Yes, please.
My lord, page 95. I will read the relevant
Side
portion.
is unrepresented insurance company.
They have taken enough time, lordship. And in
No,
my lord,
we don't dispute that, sir. But then there has to be someone.
yes,
We
it is
just
true.
can't say appeal is allowed in the terms paid for. Let the other side come. Password.
My lord, may I continue in the meantime? He will come. My part. It is up to lordship.
So wait for a while and
My
we'll
lord.
take up the next matter in the meantime.
My lord.
Item number 31.
So could you find out anything?
My lord, confirmation is yet to be made.
Then it is lapsed.
Law is very
PIT
clear.
and DPS Act.
Law is very clear.
The provision, statutory provision by itself. This is really shocking. And as a matter of fact, when we were going through the brief,
My lord,
is your officer authorized? PIT and DPS not. Is your officer authorized? There has to be a special authorization.
my lord,
Secretary.
the officer who issued the detention.
Yes. हमने उसका प्रिंट आउट निकाला था ना एक्ट का yes not below the rank of a secretary is the officer
I'm told he's authorized, there is a notification.
he can't be an officer below the rank of secretary. Please have a look at section 3.
No, detention order is by the commissioner and secretary.
Commissioner and secretary, okay. But there is no confirmation.
Yes.
Can we have an affidavit?
Yes, we can find it.
Because that would make the things clearer.
Right.
And that would require your officers to introspect.
Interest. I know your lordship. Wow. Very difficult to. But the provision is absolutely clear. When a detention order is passed, my lord, the authority has to be on their toes to make the follow-up action.
We'll tell you.
My lord.
Just in continuous of yesterday.
My lord.
Thereafter, what happened was that Jaisalmer
My lord.
was a hub for wind energy. Many companies came in. It was highly productive. There have been spells wherein the requirement of the entire state has been met with that wind energy. But the local people, they started pilferage. They would first coerce the companies that land which you require will be taken from us on lease. All staff would be deployed from our families. And then they started committing theft of cables. They were copper cables, very precious. Hundreds and hundreds of kilometers of cables were stolen. So the cases came to be registered. They were politically sponsored, that is for sure. So when I was taking up the bail applications, I called the superintendent of police. This was a matter of national importance. And I asked him what you are doing. There were cases, 30 cases against one man, 40 against one man, cable theft, batteries stolen. So they said that, so we are making the criminal cases, you grant them bail. I said that there is something called preventive detention. They were just looking here and there. Ultimately, they started doing it under the Unlawful Activities Act. But they had no idea at all. So, even here, we find that this is the first matter which has come up of detention. There may be others, but they are not being trained. And so far as NDPS officials, NCP officials are concerned, they are a specialized agency. They are supposed to be having the know-how. The consequence of the order being sustained is 68F. That would strike at the root of this menace. So it is absolutely essential. If the official doesn't act in accordance with that, they are virtually promoting this trend.
Indirectly.
Indirectly.
Right.
So we need an affidavit regarding the confirmation order not being there. The consequence would be detention for that period is grossly illegal.
After 3 months. After 3 months.
After 3 months. We will not like to record your statement on this. Let the affidavit be there. Can we have it during the course of the day?
And today, I'm told that they are away. My principal secretary is out of station, something like that.
But then every minute's detention is illegal.
Yes.
Every
Today is
minute's
a Friday. Lordship.
Yeah, he is in custody, 16th March.
Yes, my lord.
Even no final period is prescribed.
No.
No, it is until further written. Should not have been written until further order. Specific time frame should have
Yes,
been given.
that initial order could not have been for an indefinite period.
Yes. Even if it was there for an indefinite period, within 3 months, if they had taken the steps, that would have determined if
Advisory board's report, then an order of confirmation or revocation, as the case may be.
and the scheme of the act is such that within 8 weeks.
11 weeks,
11.
The report has to be there.
So that just before 3 months, they get
Yes,
the opinion.
it goes to the competent authority for confirmation.
Exactly, man.
It's just mathematics. plain and simple.
Mathematics. I mean, if your lordship permits me, I find there are some high profile cases where I appeared and I found that everything is in order. There's small deliberate defect.
Slightest technical snag and the case is gone.
But what I'm trying to indicate is in all
It is done
cases.
intentionally.
Yeah.
I know. We
Yeah,
know
it
that.
appears, well, I'm not sure, but it appears. And
We can only
in one
convey
such,
that much.
but in one such case, I ensured that the district magistrate, that is the deputy commissioner, comes and tells us why did he do it. He said, we are not very aware of the legal niceties. I said, you know everything. You know Article 22. You know the.
Sir, there has to be a training cell for detention matters
My lord.
with the government, Union of India, as well as what I was sharing yesterday.
My lord.
Those officers at that time of the customs,
My lord.
they were so very well versed with the law. You find it difficult to surmount those detention orders.
My lord.
It was extremely difficult. But
And for the small defects, they get away.
the man is having such a profile,
Yes.
large number of cases,
And it
maybe
is-
small quantity.
Yes.
He's a peddler, it seems so.
Yes, yes. And immediately after he goes out, he will do the same
He will again do that. He is, as a matter of fact, the lawyer's friend.
friend.
So then we need the affidavit tomorrow.
Yes, as early as possible.
Tomorrow, because after having,
Lordship may fix it tomorrow because every minute now counts.
so today itself,
Tomorrow, let it be tomorrow, my lord. I'll ensure that by tomorrow it's filed. Tomorrow, Lordship may take it up. In the second half, my lord, so that by any means in the first half, I
no,
file.
no, then we'll release it from, we have not parted, we have not made it parted.
My-
Okay, then council, Shri Mujumdar.
Additional.
Additional Advocate General, Shri Mujumdar, please for time to file an affidavit
Right.
of the competent authority to satisfy the court whether any order of confirmation of retention of the petitioner pursuant to receiving the report of the advisory board has been passed or not. List tomorrow. As a matter of fact, you will have to advise them to release him forthwith.
We will start the process from now on. Yesterday, while getting the instruction, my lord, I had a feeling that every minute will now count. Because 3 months.
Even ignoring it right now reflects on us.
So since your
We
lordship
don't want
requires
to record your statement.
my deeply obliged.
I am obliged.
Obliged. We need the detailed judgment. We need the original judgment. This is on the Rajasthan High Court website. You have got the original judgment. You take it out. Take it out.
Man, if the citation is given to us about the Rajasthan judgment, we can find out, man.
You have a look at this citation. There's another. Listen. Pass it on. No, we'll give you the printout. Just in a moment.
Mine.
And these are the consequential orders we have passed. You can have a look at one of them. Ye de dena.
I'll read all these. Man.
Can resistance. Can resistance.
Maybe there are some good practices. No, I told you to carry from there some to be conveyed there. The petitioner in person. Yes, this is the judgment. These are Majumdar sir. This is the original judgment.
Item number 23, time being.
Lordships, my writ appeal page number 111.
Lordship, may I, Lordship?
Yes, ma'am, please.
Lordship, in page number 109 of the writ appeal, Lordship.
One nine.
109.
Yes, please.
We have filed the additional affidavit, Lordship, in the writ petition. Lordship, have got that?
Yes, please.
Lordship, in page number 110 is the relevant portion. If I may read, Lordship. Para 4.
Yes.
That the Assam India Company Limited was declared insolvent by a public announcement dated 31st of October 2017, issued under Regulation 6 of the Insolvency and Bankruptcy Board of India, and the petitioner name was asked to submit his claim, but after submission, a claim of rupees so and so, and the same was rejected on the ground that the petitioner was fully paid as per order of the Honorable Supreme Court. So, Lordship, I think before the Honorable Single Judge, during the course of hearing, this point was not placed before the Honorable Single Judge, that we have made a declaration in the pleadings itself, in the additional affidavit.
What about the consequence of the proceedings, madam?
Consequence, Lordship, our claim was rejected, Lordship.
Whether this fact is disclosed, it's not. Be fair to the court. You are an amicus.
Yes, Lordship, but it's written in the same was rejected on the ground.
Yes, rejected on the ground, yes.
That the petitioner was fully paid.
Very well, then maybe you can escape cost.
Yes, Lordship, it is written there. And Lordship, in the writ appeal also we have mentioned it. And we have made...
Because
Lordship, his remedy would have been section 61 of the IBC.
That's right.
He didn't go there. He came for a petition.
That's right. What do you say to the statutory remedy under the IPC?
Yes, Lordship, we went to the IPC, Lordship, as an operational creditor, but here we are on the fact that it is, here our contention is based on the fact of reinstatement, Lordship.
That is okay. Any sort of monetary relief against a sick company for which a resolution process has been issued and your claim having been rejected, this court will not be required to go into those things. Very well. Thank you.
Deeply obliged, Lordship.
Thank you for the assistance, madam.
Item number 17, round.
Yes, please.
Your Lordship, this is a matter pertaining to the rights of a transgender persons who are one of the marginalized section of the society.
Yes.
Before coming into this petition, your Lordship will be knowing that even after the independence, even when the Constitutional Assembly debates were going on, no one was there to speak about the third gender and transgender, and which forced us for the last 65 years to remain marginalized, being sidelined from the mainstream society. And it was after the Supreme Court intervention in 2014 when the Nalsa judgment came into place. And we have been recognized as the third gender. And after that, what discrimination in this matter is concerned, your Lordship will see. The government of India came up with a health insurance scheme, which is known as Ayushman Bharat or Pradhan Mantri Jan Arogya Yojana. In the state, the government came up with another health insurance scheme, which is known as Atal Amrit Abhiyan. So far as after my intervention, the transgender community of Assam were inducted in Atal Amrit Abhiyan. But so far as the packages and procedures that are concerned to the Ayushman Bharat card, there is one package which is known as reconstructive surgery, Now, if we go into the deep of the entire meaning of the reconstructive surgery, which enables also the procedure pertaining to sex reassignment surgery and gender reassignment surgery. So when I asked in question to the concerned authorities, they said that this Ayushman Bharat scheme is based on 2011 socio-economic caste census. So now for the time being, even if we consider the 2011 socio-economic caste census, the population which was calculated under that census were given this facility. So why not transgender was included under this scheme when the socio-economic caste census not only discloses the population of male and female, whereas it also includes transgender in its population.
Absolutely true. Right.
So, in another sense, 2011 population census came. 2011 population census talks about Assam has a transgender population of 11,374. Whereas in the same year, 2011, socio-economic caste census says that transgender has a population of merely 1,500. So which is
Why the
again a
discrepancy?
contradiction.
Why this discrepancy? Has it been explained? Is there a pleading to this effect?
No, nothing.
Is there a pleading to this effect in your petition? Have you made a pleading to this effect?
Yes, yes, yes.
Okay, we'll ask them then. Yes.
For that, the government of India is required to clarify on this issue.
Okay. No clarification.
Nothing,
so far?
nothing till date.
So should we first ask them for this clarification before
Yes.
proceeding further? Government of India,
Lordship, I can take that clarification. I can take that clarification.
why are we waiting? These are very sensitive issues. This mindset has to change.
So, Lordship, I am with
You
the
can't be in a slumber when these sensitive issues are taken up. This is drastic. 11,000 to 1,500. What kind of skewed consideration is this?
Lordship.
We need this clarification and rectification if so required within the next 2 weeks. It's not rocket science. You just need to correct your records, that's it.
I'm with you, Lordship.
And the petitioner would assist, we are sure.
Yes.
So first and foremost, we take down our contention, the petitioner's contention, and we need you to respond to that immediately.
Lordship will give a direction to that effect.
Yes, the petitioner present in person submits that in the census 2011,
yes,
Assam
population census,
Assam population census 2011, comma, the population of transgender community was assessed at 11,000. Where have you mentioned it?
11,374. In fact, I have enclosed the document as well.
Please let us see.
Page 189.
189. 189.
189. Your Lordship will see the amended petition.
Yes, we are having that.
That 30.
189.
189. Annexure 9.
In India, it is 4,87,000.
Yes. In 13 number point, Assam has 11,374.
It's item number 11,374. Whereas in the which is the other statistics you are referring to?
Socio-economic caste census.
Where is that?
এফিডেভিটত আছে নেকি এমেন্ড কৰাৰ পিছতে মানে কনফিউজন হৈ গৈছে It says some 1700.
Whereas as per the socio-economic and caste census 2011, statistics of socio-economic and caste census 2011 available on the website of the Government of India, the number is shown as 1734. Then at council representing the Union of India shall.
Your Lordship, there is one correction. The website, the screenshot which I have placed, that is of, I think, rural. Your Lordship.
Rural.
Rural.
Okay.
And this is the same socioeconomic caste census 2011. This is the urban.
So we have to count them together.
Yes, rural and urban.
What is the total then?
Here it says it's only 160.
Rural qualified as rural is 1734, whereas for the urban areas it is shown as 160 only. Then at council representing the Union of India shall file affidavit of the competent officer or authorized officer to explain this discrepancy. He shall also instruct the authorities to take remedial measures for rectifying the error, if any.
Lordship will fix a time frame.
Yes, needful shall be done positively within the next 2 weeks.
Lordship.
Re-notify on 14th March.
Your Lordship may just please add that this is the part of the Government of India which is required to be done. But so far as the state is concerned, we have no, even we are till date, we have no any medical facilities. Because if suppose if any transgender is suffering from any road accident or any other major diseases.
Why do you feel that there is any discrimination? Well, road accident, it is a human being.
Your Lordship.
What difference does it make?
No, Your Lordship, I have an experience on that.
Okay.
It was the community member when I received a call at 1. This is off the record.
Yes.
At one
This
in the
matter,
midnight, I
technically, it
received
would
a
not
call.
matter. Don't worry. Yes.
So at 1 AM in the midnight, I received a call. And when I went to the place, it was the Guwahati station where a transgender was being sexually assaulted and was thrown from a train.
Oh my.
I immediately took her to the Guwahati Medical College, and Guwahati Medical College didn't give us an admission, saying that we have only male and female wards. We don't have separate wards for the transgender. Then again, we have to immediately shift her to the critical care hospital in the highway.
We may stop you here. The solution to this problem, probably, we can take up this issue under the aegis of the State Legal Service Authority, organize a sensitization program, and we'll request you to lead the affairs. Okay?
Yes.
We can sensitize everyone concerned. First and foremost, the officials.
Even there are many instances where Your Lordship.
We'll implement the Secretary, Assam State Legal Service Authority, Suomoto. Let them come out with the solution. And you just suggest the bullet points which need to be addressed urgently.
Yes.
We'll take care of the things.
In fact, Your Lordship will find on the previous order in this PIL only. The government has filed an affidavit assuring that we have opened a 6 ward rooms for the transgenders.
No, opening a ward separately is not the answer to the problem. All the wards have to be open for everyone.
Yes, but Your Lordship, that is by virtue of section 15 of the newly enacted transgender.
That a separate ward has to be done. It's okay, but that is an additional facility. Otherwise, a hospital is for human beings.
No, Your Lordship.
Irrespective of caste, creed, gender.
Absolutely. But Your Lordship, why the contention is here, we need a separate word is because most of the transgenders, they remain on transitioning period.
Right.
Suppose if we are giving any medicines that are not required to be given to a sugar patient, that may have an adverse effect.
Okay.
So in case of transgender who are in transition, or who wants to have a separate medical facility,
Understood.
we can't collect them with the male and female.
That's right, that's right.
So that is why we want
So
a
that's
separate.
why we want you to assess the court. We'll have some kind of sensitization program wherein you can highlight these issues. These are not the matters required to be taken up in the courts. We can have it under a different kind of umbrella. And we assure you that we'll take them forward. We appreciate your efforts definitely. So the Assam member secretary, Assam State Legal Service Authority is implemented as a party respondent in the writ petition. Copy of the pleadings be provided to him. The petitioner shall summarize the issues to be addressed in a summary, in a short brief note, which shall be shared with all learned counsel representing the respondents. Re-notify on. We can have it on 14th March.
Your lordship may fix it in the month of April.
Very well.
Because on the next month, I will be busy in the Supreme Court.
Okay, okay, very well.
Because we have in fact, we have challenged that newly enacted Transgender Act, and that
Then
is
we'll
coming
have
up
to
before the
post it
court.
as last week of April, because in the middle of April, there are too many holidays. 27th April. In the
Yes,
meantime,
fine,
please
absolutely.
get that discrepancy rectified. That makes a huge difference.
Yes, yes.
And the schemes applicable, if these things are rectified.
Even in fact, your lordship, the new issue which is now coming up before all the judicial officers in the lower court is that whether the transgender marriage is legal or void or voidable.
Let the Supreme Court take a call on that. Thank you.
Matter number 18.
Yes, please.
May I please, your lordships? Lordship, in this PIL, already eviction process is already been completed in this reserve forest. However, some indigenous people are still staying there, and they've applied for their forest right under the scheduled tribes and other traditional forest dwellers recognition of their rights.
So you have filed the affidavit or not?
Also, however, we'll file it affidavit in this regard.
Today,
No, Lordship, sometimes maybe granted.
let's give him counsel to the respondent. Praise for, and is granted further opportunity of 2 weeks. File the requisite affidavit in terms of the order dated 27/1/2020.
My lord has fixed certain items, similar items at a particular date and time. No?
It will come up before the same, don't worry.
My lord.
Item number 26.
This is item number 20. No, this one we took up. 18. 26.
Lordship, this is an appeal filed by the state lordship against order dated 22/4/2021, passed by the learned single judge lordship. In this case, lordship, the learned single judge directed the state to reinstate the petitioner who was suspended under section, under Rule 6(2) of the Assam Disciplinary and Appeal Rules 1969, Lordship. Lordship, may kindly see the impugn order at page 156, Lordship.
Page number?
I'm coming to the judgment is at page 151, Lordship. I'm coming to the operative portion, that is at page 163. May I read, Lordship? Lordship, in view of the aforesaid facts and circumstances, this court has no other option but to follow the decision of the division bench in the case of Rakibuddin Ahmed. Accordingly, orders of suspension which are not reviewed within a period of 90 days and where the so-called notice has not been issued are set aside and quashed.
Yes. So
And-
this is revocation of a suspension order.
Yes, Lordship.
Okay. The
The-
departmental inquiry continues.
Now it is continuing, but he was involved in a criminal case, Lordship. He was arrested by the police. He was under detention for more than 48 hours. Accordingly, by the provision of Rule 6(2), Lordship, he was deemed suspended. Lordship, may kindly see the law, Lordship.
Yes, please. So how long was he in suspension? How long he remained in suspension for? What was the period of suspension?
He is still under suspension.
Continues.
Yes.
The order is stayed.
Not stayed, Lordship. That is why one contempt case also pending, Lordship. There one order has been passed. That is why I have mentioned this matter, praying for a stay, Lordship. Lordship, may kindly see the first order passed in this case, Lordship. It was on 29/3/2022, Lordship.
Yes.
Lordship, may kindly see the last line, Lordship. Issue notice also on the prayer for interim relief returned on 27th. Subsequently, the matter was admitted, but that hearing is yet to take place, Lordship.
Okay.
So basically, today I am, Lordship, praying for a stay of the impugn order, Lordship.
Very well. What is the ground of challenge?
Lordship, may kindly see the rule.
Indefinite suspension, sir, is not the requirement of law.
Lordship.
It has to be reviewed, there is no doubt. What is the prosecution the employee is facing? What is the offense?
So for offense, Lordship, may kindly see the FIR at
Caught red-handed, is it?
Lordship.
He was caught red-handed.
Yes, Lordship. He was demanding and taking money from a person, Lordship, who retired from service, who went to him, Lordship, for release of pension, Lordship. Lordship, may kindly see page 43, Lordship. This is the FIR, Lordship. It's a short FIR, Lordship, page 43.
No, it's okay. We understand this PC Act FIR.
Yes, Lordship.
Section 7.
Lordship.
It's okay. Yes.
Lordship, I am basically praying on the basis of the law applicable in the state of Assam, Lordship. And in my humble submission is, Lordship, so far as Rule 6(2) is concerned, Lordship, it's a deemed suspension, Lordship. And when a person is suspended under Rule 6(2), there is no obligation.
Requirement of any formal order being passed thereafter.
That is there, Lordship. But the second portion is there is no any obligation on the part of the state to initiate any departmental proceeding against him, Lordship. So there is no requirement for issuing any so-called notice to him. So if it is not there, Lordship, if I am not required to initiate any departmental proceeding against him, there is no requirement for me to issue any so-called notice. And in that case, Lordship, Supreme Court judgment of Ajay Kumar Chaudhary is not applicable in case of Rule 6(2).
Mr. Nayak, if I remember correctly, there are some orders of this court where it has been held that Ajay Kumar's ratio applies to even cases where Rule 6 comes into play.
Yes, Lordship. Learned single judge basically dependent on that judgment, relying on that. Yes, Lordship.
Why pass that law?
Lordship, may kindly see the impugn order, Lordship.
Why don't we initiate an inquiry, place him in suspension? That is your prerogative. Why you are unless harping on this, that 48 hours custody, continued suspension? Why do you require that? Why can't you initiate? This was tapped in 2019.
Lordship.
What prevented you from initiating the inquiry so far?
On the criminal side, Lordship, inquiry is going on.
Criminal side, the trial would be going on.
Lordship.
Have you issued the sanction?
Yes, Lordship. Department has.
Then sanction issue, D can be initiated. You pass a fresh order of suspension. What prevents you from doing so?
Lordship, in my humble submission, Lordship, this is not applicable so far as Rule 6.2 is concerned, and that is what Lordship praised before the learned single judge, Lordship. Lordship will see the learned single judge's order, Lordship.
You prayed for reference of Rekibuddin Ahmad. On what basis?
That is my ground, Lordship. That is my
So if the judgment is to be referred to a larger bench,
Lordship.
any order based thereupon, whether it is liable to be stayed. Because still the larger bench answers the reference. The law holds the field.
My prayer will be if this honorable court prefers to send the matter, refer the matter before the larger bench.
Let us see the judgment first then.
Lordship. Lordship will kindly come to the rule first, Lordship.
I don't know why we are arguing.
Lordship, I am coming.
Mr. Nayak, the question is very short and simple here. There is categorical finding by the division bench in Rekibuddin's case.
No, in my Lordship.
That's
the he prayed for reference to the larger bench. 163.
No, but in this case, you are entitled to place him under suspension after
Initiating a D. Why do you want to go into this?
Even at the stage of
or even just review it and extend it. That's all.
that has been extended, Lordship, in fact. But even in case of inquiry also, Lordship, we can keep him under suspension, Lordship. That is why I am trying to place the law, Lordship. If your Lordship.
Have you initiated the department inquiry? We want to know.
Yes, Lordship.
Where is that the charge sheet? Where
That's
is the
so.
departmental charge sheet?
Yes, Lordship. Lordship, so cause was issued on 18/6/2020, Lordship.
Page number.
(143), Lordship.
Mr. Nayak, why are we agreed with this order? What is wrong with this order?
Lordship, in my humble submission, Lordship, while passing the order in Rekibuddin Ahmed, Lordship, the law was not properly, it was in fact, it was in ignorance of the law, Lordship. And secondly, Lordship, the relevant Supreme Court judgments authority prevailing at that point of time was also not taken into consideration, Lordship.
So that is another matter.
Lordship.
Merely for an academic reason, are you pursuing this appeal? Because the learned judge says you are entitled to review and take appropriate decision.
No.
You review, and if you feel that you want to extend his suspension for reason X or
Suspension order pursuant to charge sheet.
pursuant to charge sheet, you can do it.
Why can't you pass a fresh suspension order after issuing of charge sheet? This is show cause notice, whether a formal charge sheet has been issued or not.
The departmental inquiry is going on, Lordship. Along with this search sheet, Lordship, allegations of surges was also served upon him, Lordship.
The order is the big 147. This refers to the automatic suspension. I can't be possible. You see, this order 147 page, where you refuse to revoke, it refers to the earlier automatic suspension. You have a power of review. A fresh suspension order can be passed after serving of the charge sheet. Why don't you exercise that power?
No, that power is under the law, Lordship. That is there.
Then
My submission is, Lordship, so far as the Rule 6.2 is concerned, if your Lordship goes through Rule 6.2 once, Lordship,
let us see.
disciplinary and appeal rules, Lordship.
And why the interpretation of that rule by the division bench is required to be reviewed or to be considered by larger bench.
Lordship.
You'll have to satisfy us from that test.
Yes, Lordship.
Yes.
Lordship, Rule 6.2, Part 2, suspension, Lordship.
Yes.
6, rule suspension. The appointing authority or any authority to which it is subordinate or any other authority employed by the governor in that behalf may place a government servant under suspension A, where a disciplinary proceeding against him is contemplated or is pending, or B, where in the opinion of the authority aforesaid, he is engaged himself in activities prejudicial to the interest of the security of the state, or C, where a case against him in respect of any criminal offense is under investigation, inquiry, or trial, provided that where the order of suspension is made by any authority lower than the appointing authority, such authority shall forthwith report to the appointing authority the circumstances in which the order was made. Now, Rule 6.2, Lordship, a government servant who is detained in custody, whether on a criminal charge or otherwise, for a period exceeding 48 hours, shall be deemed to have been
So
suspended.
there is, gentlemen, there is no suspension order under Rule 6.1. This is an order under Section 6.2.
Yes,
Which
Lordship.
is an automatic one, which
Lordship.
does not require application of mind.
Lordship.
Now you have the power under Rule 6.1 to apply your mind and pass the order.
Yes, that is there, Lordship.
That is a default suspension.
Lordship.
That can't be continued indefinitely.
Lordship.
Why don't you advise your officers to act as per 6.1?
That is there, that option we can.
You may make it
we all
clear,
also.
you may make it clear that you are free to pass an order under Section 6.1 in view of the fact that the DE has been initiated.
Lordship. Lordship will also take note of Rule 6.5, Lordship, last one.
Yes, please.
An order of suspension made or deemed to have been made under this rule may at any time be revoked by the authority which made or is deemed to have been made the order, or by any authority to which that authority is subordinate. So far as Rule 6.2 is concerned, Lordship, only the concerned authority can revoke that suspension, Lordship. Lordship, I am also coming to that, so far as that review provision is concerned, Lordship, I am coming to the manual, Lordship.
Recuse the name of judgment.
Lordship.
Judgment of recuse the name of first letter C.
Lordship.
Because for the presently controversy is covered by that judgment. Even you are not denying that.
Page 122 of the appeal.
अरे दिया था नहीं मुझे दिया था 122
I also did. And then I put this.
Lordship, kindly see page 127, Lordship.
Yes.
Paragraph 14, Lordship, I am reading the second paragraph.
Yes.
On the point of reference, the attention of this court is drawn to the manual number 2.1.8 pertaining to Rule 6.2. Lordship, Lordship, if your Lordship goes through this rule, Lordship, this is manual 2.1.8, it pertains to Rule 6.1 only, not 6.2. That is the basic difference, Lordship. Under Rule 6.2, Lordship, there is no provision for reviewing the suspension, Lordship.
The power of review is provided in 6.5. It is not restricted to 6.1 or 6.2.
Restricted.
It's for the entire chapter of suspension.
No, Lordship.
6.5.
Lordship, for that I have to refer to the manual, Lordship. Just after the rule, Lordship, Lordship will get the manual, Lordship. Manual of departmental proceeding. I'm referring to Chapter 2, Lordship.
Gentlemen, if you read 6.5, it deals with both kind of suspension.
Yes.
A specific order of suspension and deemed suspension.
Lordship.
So deemed suspension is only under Rule 6.2.
Lordship.
Then why power of revocation is not there?
No, that reviewing, Lordship. Ultimately, the authority will revoke the suspension. That is one, Lordship. So far as review is concerned, Lordship, it pertains to only in respect of Rule 6.1. Lordship, may kindly see the manual, Lordship, Chapter 2. I'm coming to Rule 2.1.8, Lordship, manual. 2.1.8. The following principles procedure with regard to suspension need to be strict compliance. Suspension should be resorted to only in cases where a major punishment is likely to be imposed if the charges are proved. 2. Charges and the statement of allegations should be served within 3 months from the date of suspension.
Just hold on. Read 6.2. That will make the things clear. Shall remain under suspension until further orders.
Lordship.
The very use of this language, until further orders, that means the authorities are again required to consider it.
Lordship.
It cannot be indefinite. The order is not perennial in nature.
Lordship.
So there has to be this review power has to be read in this rule also, irrespective of what your manual says. We can provide you the window of considering suspension if so required under 6.1 pursuant to institution of inquiry. That would also be a futile exercise. Now 3 years have passed. What you will gain by placing him in suspension now?
Lordship. Lordship, if your Lordship gives me the opportunity, Lordship, then I would like to place certain judgment, Lordship.
Definitely.
One judgment from the Supreme Court, Lordship.
Please.
Lordship, I'm taking the judgment flag as number 5, Lordship.
Yes.
Mr. Nayak, just a minute.
Exactly. Why didn't the state challenge the judgment in Rakib and Ahmed to the Supreme Court?
Lordship, I was not party there.
That doesn't mean anything at all. You were not a party means what? State was a party. You in your individual capacity is no one. It's the state of Assam.
If Lordship convenes with my submission, Lordship may still refer this matter.
Mr. Nayak,
Lordship.
all we are trying to understand is you don't agree with the law laid down in Reku with this case, the division bench judgment. Is that correct?
We are
Is that
agreeing,
correct?
Lordship.
What do you want this division bench to do about it?
Lordship, so far as rules, we want proper application of Rule
No,
6.
but that judgment is binding on this court.
He wants a reference.
Yes, that is
Reference
why.
why? If there are
that is why-
divergent views, then only reference.
Lords, that is why I'm trying to convince your lordship.
So, all right, we dismiss your appeal, then you take this judgment to Supreme Court. Then there you can question the validity of recusal.
No, lordship, I'm just playing several judgment. Lordship will dismiss my case, lordship, no grievance, lordship. Lordship will at least go through my citations.
This academic exercise, please.
Judgment at page 5, serial number 5, Lord.
Yes.
Flag 5. I'm coming to paragraph 3.
Yes, please.
The basic issue, the basic issue in these two appeals related to the scope and ambit of sub-rule 2 of rule 2. This is in respect of CCS rule, Lordship. Vis-a-vis other provisions of the said rule. 4. Division bench of the Delhi High Court by impugned judgment in each case held that sub-rule 2 of rule 10 does not contain any provision wherefrom it can be deducted that the deemed suspension for custodial detention exceeding 48 hours would continue until it is withdrawn. It was further held that on a plain reading of the said provision, it is clear from that the said same comes to an end by operation of law after release of the employee from detention. Paragraph number 7. The background facts of the appeal relating to respondent Rajiv Kumar is referred for the purpose of adjudicating the issue involved as the factual position in the appeal relating to Bani Singh would not affect ultimate conclusion. Rajiv Singh was arrested on 26/3/1998 for allegedly accepting bribe and was released.
There is no automatic termination of this suspension order. Understood. That is, the division bench in Recusal Ahmed has not said so.
Lordship.
The only argument which you are making is that power of review is not available in an automatic suspension order.
Lordship.
So the controversy in that judgment was not that, because the Delhi High Court held that it is an automatic revocation with the release of the employee on bail, which is not the way. So how does this judgment apply?
Lordship. Then Lordship will kindly take my next judgment, Lordship.
Yes. Flag number?
Flag 8, Lordship.
8.
It was This is a division bench judgment, Lordship, passed by the Uttarakhand High Court.
So you want us to follow the persuasive value of the Uttarakhand High Court judgment as against the judgment of this court?
Lordship, these are although not authorities, Lordship, I'm trying to
So
persuade
then
you,
what's the point, gentlemen?
Lordship,
The
there are
only judgment of Supreme Court you are citing is not applicable. There is a judgment of division bench of this court which has the
Lordship,
less persuasive value.
Lordship,
Why
here,
should we
Lordship,
even refer to the other high court?
Lordship, right now I am having 7 or 8 judgment passed by the division benches of different high court.
Maybe
One full bench wherein it has been clearly held that Lordship, the Ajay Kumar Chaudhary judgment is not a binding judgment, or it is not applicable in case of Rule 6.2 or deemed suspension, Lordship.
Rule 6.2 probably the only interpretation has been done by this court. No other court had the occasion to deal with that.
That Rajiv Singh judgment, Lordship, in my humble submission is the
Rajiv
ultimate
Singh.
authority. Yes, just now I have placed, Lordship.
Flag 5.
That is the only.
Flag 5.
Yes.
That is not at all. Therein the Delhi High Court held that suspension gets revoked automatically on release of the employee,
Lordship.
which was not the correct view.
But the court said, Lordship, it will remain until and unless it is revoked by an express order by the
Until and unless means there has been a power of review. So we read in the power of review as applicable in suspensions for Rule 6.1 into Rule 6.2.
Lordship,
It can't be indefinite, sir.
my submission will be.
Supposing in a given case,
Lordship.
the case results into acquittal, still or AFR, still the suspension would continue. You mean to say that?
No, Lordship,
Then
only
Then
in
what is the provision to revoke that suspension?
6.5, Lordship, in our case, Lordship. 6.5.
Why should the authority even do it? There is no power to review. That would be a review.
Lordship,
Why should?
in my understanding, Lordship, the concern for employee, delinquent employee will file a representation, Lordship, and on the basis of that representation, authority will consider. That comes from that is why I was trying.
Suspension is a burden on the state exchequer.
Yes, Lord.
Unless you prove the employee to be guilty, paying him even the subsistence allowance from the taxpayers' money is a sin. So if you can use him on a non-financial post, use him.
I
Why
agree
you
with
pay him
you.
free salary?
Can be generalized. There are situations, Lordship. For a moment, Lordship, we'll take an example of a teacher, Lordship,
Yes,
who was accused of a POCSO offense, Lordship.
yes.
Can he be sent to the school to teach the same girl students, Lordship?
You assign him a duty in the store.
Teacher, Lordship.
Why not? Why not? Teachers are posted in election duties, are they not? Under what capacity? So this is the basic idea behind the review is that indefinite suspension doesn't help anyone.
Lordship.
You will take, how many years does it take in Assam to conclude a PCF trial? Let us know. In Rajasthan, it takes almost 10 years.
Lordship.
So 10 years, he is a state guest, getting 3/4 of the salary for doing nothing. Why this benevolence? The single judge says that put him on some kind of non-effective post. That is justified. And then if you are so eager, use your powers in 6(1). Already we are 4 years down the line since the trap was laid. You could have concluded the trial, terminate him on the basis of conviction.
Lordship.
Why don't you think of that? So far as yet, we are not convinced with the judgments you are citing. You need more time, we can give you that. Otherwise, to our mind, Recusal Ahmed lays down the correct law.
By submission, that is why, Lordship, I am trying to place the judgment.
Very well, then,
Under High Court, Lordship.
Conclude your arguments. Very well.
No, I will not take much time. So I'm just placing.
No, you may take your time. There's no difficulty. We are not stopping you.
Lordship.
It was just loud thinking. Yes.
Mr. Nayak, sir, can I get? Please try to understand the query of His Lordship. The formulation that you are projecting, the bench has already said it appears to be covered by the judgment in Rekubuddin, which according to us does not suffer from any infirmity. And even if it does, we are not going to interfere with that. We can't. This is for the appellate court to do it. So the arguments you're making and the judgments you're relying upon does not prima facie convince us. If your idea is that let me do my job and pass any order, then you give us the citation, we'll pass the order. Otherwise, you know which way it is going. If you're really serious about it and you want to do some research, that is another matter. Make up your mind. Do it quickly.
Lordship will then grant some time, Lordship. At this stage, Lordship, and then I'm only praying for stay of the impugned order, Lordship. One contempt case is pending and your Lordship passed an order for personal appearance on 3rd, Lordship.
Is there an ego issue with the officials?
No.
Then revoke the order
I
is
have
revoked.
otherwise, Lordship, so far as the contempt case is
You are
concerned, in terms of that order, Lordship, I have already conveyed the authority.
Read the observations in Ajay Kumar.
Lordship.
Read the head note first. If it is for indeterminate period or if its renewal is not based on sound reasoning, contemporaneously available on record, this would render it punitive in nature. Practice of protected periods of suspension and repeated renewal thereof strongly deprecated.
Lordship, even in Rajay Kumar Chaudhary, Lordship, he did not get the relief, Lordship.
That's a different
He
thing.
remained under suspension even after this order.
The principle underlying is very clear. Protected suspension, you are trying to sustain an order which was passed without any application of fine. Why don't your officers act as per the powers conferred upon them?
Lordship.
Why do they want to bank upon the factum of arrest only, but deemed suspension? You have that option, excise that, reinstate him, then revoke the suspension, pass a fresh one,
The issue is
seek
Lordship,
liberty.
now the situation we are facing, Lordship, it is not at all possible for the authority to comply that 90 days period. Lordship, always.
Put the DE quickly,
That is the issue. It is-
show him the door out.
And the person comes to the court immediately on 91 first day, he will come to the court, Lordship.
He
That-
will.
To take this order, Lordship. So
Yes.
that is why I'm trying to convince Lordship that 90 days period is not at all automatic, Lordship.
So, all right. You
There may be
convince us
ground,
of law.
even in the Ajay Kumar Chaudhary Lordship.
Come out with a better citation.
Lordship, even in Ajay Kumar Chaudhary Lordship, I would like to place one line only,
We are
Lordship.
not staying it, sir. That is for sure.
Lordship.
You may convince us on any other day. That opportunity we can give you. When do you want?
Lordship, in case stay is not granted, Lordship, my case becomes infructuous, Lordship. There is no issue continuing in this case, Lordship.
We are not enticed. We want a decision on merits. The issue would be closed then.
Lordship will decide this matter, Lordship.
Very well.
The
Arguments
authority
are
one then
generally
takes
resolved.
go to Supreme Court. Lordship will kindly record my submissions, my citation.
Will, of course.
Lordship.
Matter number 30.
It seems your case is going unopposed. Who is the counsel? Can you inform?
One also, earlier occasion also, he took enough time.
Who is the counsel? We don't know.
One Goswami, my lord. Ravi Goswami.
उनको मैसेज करिएगा नेक्स्ट डेट के ऊपर आ जाएंगे. We'll inform him. He'll come on the next date.
Let it be taken up at 2 o'clock, my lord.
Not at 2. My lord has some other business to attend. So we'll have it on some other day. We'll inform Mr. Goswami in advance.
My lord.
Inform करिएगा. Posted on 28th March. None present for the respondent. List on 28th March. Counsel for the respondent shall be informed to remain present on the next day.
But the last chance may be given to them, my lord. My
Last
humble prayer, because